NACDL is the association of the nation's criminal defense bar.
I couldn't possibly start a talk about jury selection without the obligatory Clarence Darrow quote. And the truth is that we all know how important jury selection is in any criminal case. But the thing about false confession cases is that in some ways they are different than any other case you're going to handle. And they are different in a way that makes jury selection particularly important. Because in your average criminal case, to some extent, any juror on your panel is going to understand that in some circumstances a witness could lie. And in your average criminal case, every juror on your panel, to some extent, is going to understand that it's possible that the police could be mistaken. But the thing about false confession cases is that there are going to be some people on your panel who do not believe that false confessions happen. And so your job in voir dire is to find those people, weed out who they are, and get them off your jury. So I believe Lisa said yesterday that there are something like people here from 34 different jurisdictions and Canada. And I understand that jury selection is a particularly hard thing to talk about when you're talking to people from a bunch of different jurisdictions. We all have different rules, different customs. I know some of you probably come from places where you don't even get lawyer-conducted voir dire. And I know some people come from places where you get hours to do voir dire, and some of us come from places where you get minutes. In Manhattan, where I practice, there is a judge who, up until recently, when she was overturned for this, only allowed 5 minutes for voir dire. So I get it. It's different everywhere, but my hope is that there are some strategies, some ideas here that you can apply no matter where you come from and what the rules are. So before I want to get any further, I need to thank a few people because it's a lot of their ideas and strategies, not just my own, that are coming into this talk today. And it's always good for you to know the names of a few more amazing false confession trial attorneys that you could reach out to. So first of all, Alice Fontier, who is now at Bronx Defenders, was vital in giving some advice here. She tried a case, the Eton Pates case in New York City, was co-counsel on that a couple years ago, tried it twice. And for those of you who don't know who Eton Pates was, 6-year-old little boy in 1979 disappeared on his way to school. It was huge in the press. He was never found. And in 2012, Alice's client, Pedro Hernandez, a mentally ill, developmentally disabled gentleman, after 7 hours of unrecorded interrogation, confessed to his murder. So next, Linda Moreno, who represented recently Noor Salman in her trial. She was the wife of the Orlando nightclub shooter. A case that ended in a not guilty verdict. The police claimed that she confessed. The defense theory was, well, not really. And then also, I want to say thank you and good luck to the Queens legal aid team on the Queens jogger case, who got a mistrial in November and are going to be trying again a case where their 22-year-old client, also a developmentally disabled young man, is charged with murdering and sexually assaulting a young woman in Queens who was jogging on Howard Beach. So the things you're going to hear today are coming from a lot of great minds on false confession cases. And so thank you to all of them. So before we talk about some of the things that you should be thinking about in false confessions, I think it's valuable to reflect for a moment on what you're up against generally. And a lot of these studies are dated, but if you look at the numbers, they don't actually get that much more encouraging over time. So starting back in the 1970s, the National Jury Project, which as far as I understand was the first trial consulting firm in the country, started surveying jurors. And they found that 67% of jurors, at least back then, were unsympathetic to defendants. 36% of jurors believed it is the defendant's responsibility to prove their innocence. And 25% believed that a defendant wouldn't have been charged at all unless he was guilty. So fast forward to 1984, you get the National Center for State Courts. National Center for State Courts regularly does national surveys on all kinds of different issues relating to the judicial system. And in 1984, just about 15% of people who had actually served on juries believed it was up to the person accused of a crime to prove their innocence. So fast forward again, 1998, and you get a study from Professor Bradley Saxton, who at the time was a professor at the University of Wyoming College of Law. And he actually did this great study where they surveyed jurors who were coming out of court having actually served on criminal juries. So they were jurors who were listening to the evidence, hearing the instructions, deliberating, and finding people either not guilty or guilty. And even the people who had been through that process, only 60% of them correctly responded that the fact that a state had brought charges against the defendant was not evidence. So 40% of jurors who had actually deliberated thought that it was. And 31% of those jurors who had actually been responsible for deciding somebody's fate believed that once the state produced evidence that the defendant committed the crime, the burden shifts to the other side for the defendant to prove his innocence. A year later, and I kind of find this one the most frightening of all, another survey by the National Center for State Courts, and 18% of people agreed with the statement, "I would prefer that a judge ignore the law to ensure that a defendant is convicted." So just think about this in your jury selection. I know it's 1999, but I'm not sure we have a lot of reason to believe things have changed that much. 1 in 5 people on your panel agrees with that final statement. So with that in mind, what are the goals of your voir dire in your false confession case? Well, really, they're not all that different than your goals in any case. Most importantly, your goal is to deselect jurors whose belief system, whose attitudes, whose experiences, whose beliefs do not allow for the possibility of a false confession. You have to find those people and you have to get them off. Now, depending on the theory of your false confession case and the specifics of your false confession case, your goal could be more specific than this. For example, you may need to weed out people who think that a mentally normal or your average adult without deficits would never falsely confess. You may need to find and weed out people who think that a false confession would never happen with some sort of great amount of detail. And often, what you actually need to do is weed out people and get rid of people who think that no one would ever falsely confess to a crime that's as terrible, as horrific as the crime that you are saying your client falsely confessed to. Secondly, and I would say that this one is far, far less important than the first, you need to educate jurors about your case and your false confession theory. And third, build rapport with the jury. Be more likable and relatable than the prosecutor. And if your prosecutors are anything like the prosecutors at the Manhattan DA's office, who tend to ask questions like, if I prove my case beyond a reasonable doubt, do you promise to find the defendant guilty? This one shouldn't be that hard, so we're not going to spend a whole lot of time on it. We're going to focus on number one. So, what are not goals of your voir dire? Changing jurors' minds. I don't care what jurisdiction you're in or how much time you have for voir dire, but there is no way that in that voir dire that you are going to be able to change the minds, change the beliefs, change the attitudes of the jurors who have come into that courtroom. Those jurors are going to walk into the deliberation room the exact same people with the exact same ideas that they were when they walked into that courtroom. And if you think that voir dire is a chance to try to change that, then you are making a terrible mistake. When you get terrible answers during voir dire, this is not a time for you to be arguing with that juror and trying to get them to see the light. There is rarely a time when you get a bad answer in voir dire where your response should not be to smile, to thank that juror for their honesty, to say whatever follow-up questions you need to say in order to get to a for cause challenge, and then say, who else on the jury, who else on the panel agrees with Mr. Smith? That is what you do with a bad answer. You embrace it. You don't try to fight it. And secondly, you are not selecting jurors that lean in your favor. I know it's called jury selection. It's a complete misnomer. It is jury deselection, because if you spend your time in voir dire trying to call out the jurors that lean in your favor, they are going to get struck by the prosecution. And I don't know how many times that I have sat down from a round of voir dire and my client has leaned over and whispered to me something along the lines of, I want that guy who thinks cops lie. And then they're completely dismayed when that person is immediately struck, often for cause. You aren't selecting a jury, sadly. So let's see. Let's get to what jurors believe about false confessions, because it's a useful starting point to know what jurors believe about this topic, what the likely thoughts are of your panel when you are starting to craft your voir dire. And it's really useful that there have been a number of different studies, I think one or two that Dr. Gitlin mentioned this morning, that actually tell us what jurors are thinking, what your panel is thinking. And so I want to go through some of these beliefs that you need to be keeping in mind. And the study that I'm going to be citing from was a 2010 study by Mark Costanzo, Netta Shaked-Schroer, and Catherine Vinson, entitled Jurors' Beliefs About Police Interrogations, False Confessions, and Expert Testimony. And just for your use, this was in the Journal of Empirical Legal Studies. And what they did here is they surveyed 461 jury-eligible people in a number of different cities, and they made sure that these people actually reflected the composition of the jury pools in these different cities. I think they included Chicago, Green Bay, Las Vegas, San Francisco, Sacramento, New York, Los Angeles. And they gave the jurors, or the mock jurors, I suppose you would say, a list of statements. And they asked them to rate their agreement or disagreement with these statements. And they also asked them to estimate the percentage of false confessions in different cases. So what did jurors believe? Number one, jurors in this study believe, and your panel will believe, that police interrogators are better at telling truth from lies than the average person. This was something like 53% who believed this, 22% not sure, 25% said no. And this is something that we know is not true. And they also believed that experienced police interrogators are even better at telling truth from lies than an inexperienced police interrogator. So the more experience, the more that jurors believe that they have some sort of special lie detecting ability. Jurors believed that they can tell whether a confession is true by watching it on videotape. They're less sure about audio tape, but 40% of the jurors surveyed that they would be able to tell whether or not it's true. Now, the good news is that, generally speaking, they wanted to hear from your experts. They believed it would be helpful to hear from experts about interrogations when deciding if a confession was true or false, and they believed that it would be helpful to hear from an expert about why someone would falsely confess. But what is kind of frightening about this is that that was 75% on average of the jurors surveyed. So that means 25% are not sure whether or not they care about what your expert has to say, or they know they don't care about what your expert has to say. So certainly something to think about when you're doing your voir dire. Another belief was that police should not be allowed to lie about inculpatory evidence. And the belief was pretty strong. 9.5% of jurors agreed with the tactic of police falsely claiming to a suspect that he or she had failed a polygraph. So you get 90% of people thought it wasn't true. And the numbers go up, but just slightly, for things like lying about the presence of an eyewitness or lying about the presence and the match of DNA. But the thing to remember about this is that just because they disapprove of the tactics doesn't mean that they necessarily think they're provoking or causing a false confession. Again, jurors generally disapprove of promises being made of leniency or threats of harshness, but again, doesn't necessarily mean that they think these are producing false confessions. Now, they also thought the police should have to investigate to determine if the person actually committed the crime before subjecting him to interrogation. Imagine that. And they actually thought that rates of false confession are relatively high. They ranged from estimating 19.5% of confessions were false in child molestation cases all the way up to 24.2% being false in theft. Murder was at about 22%, which is interesting because theoretically, by and large, jurors believed that these false confessions are happening. And so the jurors on your panel theoretically can believe that false confessions are happening. But here's the key. They don't believe that they themselves would ever falsely confess. And the numbers here are overwhelming. 91.3% disagreed that they would ever falsely confess, even to a minor crime. And 93.3% disagreed that they would ever falsely confess to a serious crime. So while your jury theoretically can believe that this could happen, if they are putting themselves in the shoes of your client and thinking, what would I do under those circumstances, they do not believe that they would falsely confess. So now that we've gone through these beliefs, we've talked a little bit about what you are likely to encounter when you're voir diring on these things, how do you sort through this to figure out the juror that you actually want? And this may seem a little odd since we've just talked about how you're not selecting a jury, you're deselecting a jury, but certainly if you know the general idea of what you do want, you also get a pretty good idea of what you don't want. So, there's holes on the stage. All right, so I admit that the profile of the juror that you're going to want is going to depend a lot on the specifics of your case. But I think there are some general things that you're looking for for your jury on a false confession case. And the first one is somebody who is suspicious of authority or concerned generally about authority's abuse of power, suspicious of law enforcement. I think it's fair to say that in any false confession case, you are going to be giving a pretty harsh critique of the actions of the police in that case. Whether you're going to be saying that their interrogation tactics were too coercive, whether you're going to be saying that they offered information that contaminated the confession, no matter what it is, you're not going to be painting a very good picture of the police. And so this is a particularly important thing to address in voir dire. Now, in a case with terrible facts, as often false confession cases have, and in a case with a confession, it can be particularly hard for a juror to vote not guilty. And so while in any case you are looking as a defense lawyer for people who are resistant to social pressure, it is of particular importance in the false confession case. I'll just give you an example. In the first trial of Eton Pates in New York City, one juror held out against 11 voting for guilty for 18 days before a mistrial was declared. That's who you want on your jury. Another thing you're looking for is somebody with understanding of and empathy for mental health issues. Depending on the facts in your case, you may be introducing evidence that your client suffers from some sort of mental health issue. And certainly you want people who maybe have some exposure to that, and not just exposure to it, but an understanding of how mental health can be affected by stress, how people with mental health could have issues with judgment or reality or coercion or any of those other issues. You want people who think in nuances, people who see things in shades of gray, because your black and white thinkers are going to be people who very likely are going to equate the fact of a confession with automatic guilt. You want people who believe in the special knowledge of experts, people who believe that experts have valuable advice to offer, people who rely on experts in making decisions in their own lives. You want people who are empathetic. And when we normally talk about empathy, we talk about being able to put yourself in someone else's shoes. And I want to say that I think here that is very dangerous. Because we've already heard that when people put themselves in the shoes of somebody who is falsely confessing, they don't think that they would falsely confess. They cannot imagine that. So by empathy, what I mean instead is somebody who has an understanding for and consideration for the feelings and the experiences of others, even if those experiences are not their own. And finally, you want somebody who's able and motivated to dissect jury instructions. The difference may have been small in the studies that were talked about, or the study that was talked about this morning in terms of the difference that jury instructions can make. But any difference is a good difference for you. So you certainly want people who are actually going to care about those jury instructions, look at them, and apply them to the facts in your case. Now, you'll notice that in talking about the profile of the juror that you want in your case, I have not talked about demographics. And that's because the science overwhelmingly, and the experts here can correct me if I'm wrong, the science overwhelmingly tells you that demographics are not a reliable way to pick a jury. You cannot rely on things like age, education, sex. You're not going to get anywhere. But the thing that the Costanzo, Vinson, and Juror study tells us from 2010 is that race matters. Non-white jurors have less confidence in the abilities of police. Non-white jurors generally estimate higher rates of false confessions. And non-white jurors were more likely to see themselves falsely confessing, something that the pool overall couldn't really do. And so what does this tell you about your jury selection? It tells you, like the lawyers that were up here just before me, you have to be on top of Batson. You have to be making challenges, and you need to also be considering making challenges to the underrepresentation of constitutionally cognizant groups in your veneer. Now, if that is something that you can do in your jurisdiction, or if you are thinking about doing that, I would really recommend looking at the website for the Equal Justice Initiative. They have some great sample motions about representation in the veneer that you can take and you can use and adapt to your jurisdiction. But what the takeaway from this is that it matters, and it matters a lot. So I had a mentor when I started my career, a great criminal defense lawyer who taught me the strategy of paper them to death. You file as many motions as you can come up with on every issue you can think of until they just want you to go away. And it works. It really works. And it is no less important in voir dire. And this is because when you're picking a jury in a false confession case, you have more things that you need to deal with than even in your average voir dire. There are a lot of topics that you may need to get into, and you really need to get to the honest beliefs of your jurors. And so you need to use every tool in your arsenal to get everything that you can have in your jury selection to have the best opportunity to find out the beliefs, the attitudes, the experiences of the people on that panel. So I'm going to go into a couple of these in more detail. But overall, consider filing motions. And there are so many topics you can file on. For those of you who don't get lawyer-conducted voir dire, file a motion for it. File a motion for juror questionnaires. File a motion for extended voir dire time. File a motion for individual or sequestered voir dire. File a motion for exercising strikes outside the presence of the jury. And for those of you who don't already have that, I'm sorry. I did not know that was a thing until this training. But file a motion, if you're doing court-appointed work, to get the money to have a jury consultant. File a motion for increased number of peremptory challenges. So, to talk a little bit specifically about some of the, I think, more important ones here, they're all important, but motion for lawyer-conducted voir dire. Just curious, who here doesn't get or practices in a jurisdiction where you don't get lawyer-conducted voir dire? Okay, the rest of you don't have to listen. Maybe other people left. This really is vital because judges have different motivations and different goals than you do in your voir dire. Their goal is to get the jury picked as fast as possible and to get everybody to say that they can be fair. They're not going to ask open-ended questions. They're not going to ask follow-up questions. They are going to basically rush things along as fast as they can, and they're not going to know your theory of defense, and I certainly don't think you're going to want to tell them your theory of defense in the level of detail that you would have to do in order for them to be able to ask the right questions. And I'm sorry I don't have the studies up here for you, but I know that there have been studies done that show that jurors feel more intimidated and are less likely to give honest answers when being questioned by a judge rather than being question by an attorney. They feel like they need to give the right answer, not the honest answer. So I'm not going to go through all the case law out there, and I apologize, it's small. I'll make sure that the slides are available so that you have it if you need it. And there's a lot more case law on this issue out there other than this. But what is important for you to know is that even in your jurisdictions where lawyer-conducted voir dire is not mandated by the statute, it's still within the judge's discretion to allow. And it's still within the judge's discretion to allow it in order to make sure that you have an opportunity to intelligently exercise your peremptories and to ensure that your client actually has the ability to pick a fair jury. Motion for a juror questionnaire. Now, a juror questionnaire, particularly in the jurisdictions where you get a very limited amount of time to voir dire the panel, can be particularly important in figuring out ahead of time who you need to talk to and who you can just get rid of, and where to focus your time and energy in voir dire. And I think that what you might actually find is that judges can be particularly receptive to the idea of a juror questionnaire. And you can help this along, because if you go in to that courtroom talking about all the things that the social science tells us about jurors' misconceptions about false confessions, their preconceived ideas, and you talk about all the different areas that you're going to have to get into in your voir dire and the time you're going to have to spend questioning people on these different issues, the judge might actually be attracted to the increased efficiency that a questionnaire is going to allow, because it gives you a chance just to get rid of the people that there's no need to spend time actually questioning them in oral voir dire. The other things a judge might like is the privacy it offers jurors, because you could actually agree to have the questionnaire sealed. They also might like the fact that it takes away the issue of you potentially tainting the jury when you ask about press coverage or what people already know about the case. So if you're looking to get a juror questionnaire, a good place to start is talk to court staff, talk to lawyers who practice in front of that judge, and find out, has this judge ever allowed a questionnaire before? What was it for? What kind of case was it? What were the circumstances? And then track down the lawyers and get a copy of the questionnaire. If the judge denies the questionnaire, consider maybe just asking for one on a couple limited topics. Maybe the sensitive issues that you're afraid jurors aren't going to be willing to talk honestly about in front of the entire panel. But one thing to keep in mind is that if you get a questionnaire, make sure you're correlating the length of the questionnaire with the amount of time that you're actually going to have to look at it before you have to voir dire the panel. Because you could get a 10-page questionnaire of answers from every juror on your, say, 50-person panel, but if you only have a few minutes to look at that questionnaire before you're actually going to start asking questions, it doesn't do you a lot of good. So last motion I want to talk about, again, sorry, it's kind of small, is the motion for individual voir dire. And the reason I want to talk about this is because Linda Moreno, in the Noor Salman case, moved for individual voir dire and lawyer-conducted voir dire. It was federal court, and got it. And it was absolutely crucial in what happened in that case. Because in a case like that, the wife of the Orlando nightclub shooter, there was so much press coverage and so many families of victims in the courtroom that there was no way to question those jurors about what they already knew about the case and what they already knew about the confession without tainting the entire panel. And it does seem to happen that false confession cases are often press cases. There is some evidence for supporting that false confessions happen in serious cases, and there could be a variety of explanations for this. It could be that it's those serious cases where officers are feeling the pressure to close the case, so they're using coercive tactics. It could be that false confessions are happening in all kinds of cases, and it's only the serious cases where we're actually finding out about it, because those are the cases with forensic evidence that actually allow for exonerations and actually allow for proof that confessions are false. But for whatever reason, these cases are often serious cases, they're often press cases. So a motion for individual voir dire, where you're talking to each juror one-on-one by themselves, is absolutely crucial. All right, so you've won all your motions for individual voir dire, you've won your motions for a questionnaire, you've won your motion for lawyer-conducted voir dire. So what do you actually ask about? Now, it's always going to depend on the case. It's going to depend on your theory. The lawyers before me talked a little bit about how it was very specific to their theory in their case, but I think that there are some general topics that are going to very frequently come up in false confession cases that you should consider talking about. And the first one is willingness and ability to understand and accept expert testimony. Because some jurors simply are not open to what experts have to say. And to illustrate this, I'll use the self-disclosure technique that you use in voir dire sometimes. But I have an Uncle Steve. Uncle Steve lives in Beaver Dam, Wisconsin. And my Uncle Steve does not believe in climate change. He believes that climate change is a bunch of hooey invented by tree-hugging liberals. Now, I have never spoken to my uncle about false confessions, about interrogations, and honestly, I try to avoid talking about my work with him altogether. But I know that I do not want Uncle Steve on my jury considering whether or not he should listen to my expert witness. And I think if you think about it, you all probably know people who do not consider what experts have to say. And you need to find these people during your jury selection. Do they rely on experts to make important decisions in their lives? Why? Why not? What's their educational background? You know, have they taken classes? Did they attend college? Did they attend college where they took classes where they were taught by people similar to the expert that you're going to be calling? Did they enjoy those classes? Did they find them interesting? Do they believe that experts are opinions for hire? Do they believe that social science isn't real science? All of these things and more, I'm sure you can get into to figure out if they are going to rely on the opinion of your expert. So next, negative feelings about psychological defenses. And I think you should consider getting into their opinion about these defenses generally. So you may not be arguing, obviously, that your client was insane or something along those lines, but people who think that psychological defenses are an easy out for people who commit crimes are probably not going to be receptive to what you have to say about the false confession in your case. And this could be a good place to try using scaled questions. Scaled questions are questions where you ask a juror, how much they agree, disagree with a particular statement, or even ask them to rate their agreement or disagreement on a scale of 1 to 10. So you could ask them about these statements. Do they agree with them? How much do they agree with them? Psychological defenses, you could offer the insanity defense if they don't understand what a psychological defense is. They let too many people go free. How much your juror agrees with that is probably going to give you a pretty good idea of if you want them on your jury. People who commit crimes use mental health as an excuse. People who use mental health problems as an excuse for bad behavior. All of these questions, these statements, going to give you an idea of whether or not this is a good juror for you. So similar to their feelings about psychological defenses, their feelings about mental health issues. Do they have experience working in a mental health field? Do they know somebody with mental health issues? And it's really not do they know someone. It's more about what is their relationship with this person? How has mental health, their mental health issues affected you? Because I've spent a lot of my career representing teenagers. And I very commonly encounter parents who are the parent of some teenager with a pretty severe mental health issue. And their reaction to that mental health issue is, it's a discipline problem. They have very close connections with somebody who has a mental health issue. That doesn't mean they're a good juror for your case. It's about their attitudes, their beliefs about those mental health issues that matter. Also, get into their feelings about mental health professionals. Do they have experience with mental health professionals? Negative, positive? Do they feel that mental health professionals are overdiagnosing people? And again, just because they have experience with mental health doesn't mean they're good for the defense. Their feelings and experience with intellectual and developmental disabilities. Depending on your case, depending on your client, and whether or not you are going to be putting on evidence about your client's intellectual or developmental disabilities, this may be a very important topic for you to get into. And I just should say right off the bat that a lot of what is here is from the great Andrea Lyon in an article that she wrote in 2008 in the DePaul Law Review. If you have this issue in your case, I very much suggest going to that article and reading everything she has to say about how to deal with that as part of your defense. But there are a number of misconceptions and preconceived ideas that people have about people with intellectual and developmental disabilities that you need to be prepared to deal with if you're going to be presenting evidence about your client on this issue. So there is a generally held belief that you can look at somebody that has one of these disabilities and you can tell. And there are jurors, you're going to encounter jurors who believe this. They believe that the person's gonna have facial features like maybe somebody with Down syndrome, that you're gonna be able to see it through their posture. We all know that this isn't true and that people with intellectual disabilities can look like anyone else, but you have to deal with this belief. You need to ask your jurors about this belief. There are also going to be plenty of jurors, and the prosecution is definitely going to feed into this belief, that think that if your client can do basic things like take the bus somewhere, therefore they're going to say, well, they can definitely read a bus schedule and do all that, that means they don't have an intellectual disability or a developmental disability. And you heard about how there is this beginning stage of a lot of interviews where there's rapport building. And they're going to ask your client about what they did on the day of the crime or maybe what they did that day. And they're going to point, during the trial, the prosecutor is going to point to those things, those basic activities, as evidence that your client doesn't have an intellectual or developmental disability. So you need to deal with this in voir dire. You can ask, if you heard that Mr. Smith, took the bus, or whatever other factors are going to be relevant in your case, does that mean to you that he doesn't have an intellectual disability? Ask them about relationships with people with intellectual disabilities. What is that relationship like? How close is it? What do they do with that person? All of these ideas you want to talk about. And also possibly the idea that somebody, let me take that back. In my experience working with people with intellectual disabilities, a very common thing is for the person to want to hide that disability as much as possible. and to really try to show that they are fully functioning, and they will do this during the interrogation. They will try to prove to the officers that they are as fully functioning as anyone else. And it's things like that you may need to be able to deal with on this topic during your voir dire. And of course, attitudes towards law enforcement. This is something that fair to say you're probably going to be asking about in many, many cases. But inevitably, in your false confession case, you are going to be arguing that the law enforcement that was charged with investigating your case and interrogating the client is, in one way or another, making a mistake, making assumptions, and heaven forbid, lying. And so you need to know how receptive your jurors are going to be to these arguments. And so there are a number of questions, and I by no means think that this is an exclusive list of what you can be asking about feelings about law enforcement. But it's probably important to go to some of those beliefs that we know about jurors, beliefs about officers' ability to detect false confessions, and ask them, are police officers likely to believe that they are good at detecting lies? Are they better than regular people at detecting lies? Are they likely to admit mistakes? And you might get a lot of insight into how receptive your jurors are going to be and who you might want to get rid of on that panel. Now, life experiences. There are a lot of life experiences that could be relevant in your false confession case. The typical false confession case involves a scenario that you've heard about a lot today. This scenario where somebody is under so much emotional stress, so much psychological stress, that they end up with this feeling of hopelessness and that there are no other options. And they end up in a situation that because of this feeling, they aren't able to make judgments based on long-term consequences. They essentially disregard rational thinking about long-term consequences. And representing teenagers charged with serious crimes, this is something that I see happen every day. Emotional stress, psychological stress causes somebody to be unable to have that kind of clear judgment about where things are going to go down the road. But I think even people who aren't criminal defense lawyers have had this experience in their life in one way or another. There are certainly things in people's lives that cause emotional stress, psychological stress, where they've either themselves or have seen somebody be in a position to not be able to think clearly or even disregard long-term consequences. This can happen in extreme financial distress. It can happen with a very sick family member or the death of a family member. And so you may want to get into these situations and ask people about these circumstances in voir dire. Another thing you might want to consider asking about is experience interviewing. And Deja made a very good point, which is what this really goes to, is that the interrogation is not an interview. And it is not at all what your average person's conception is of an interview. But you're going to have people on your panel who probably interview as part of their jobs. And most people at least have been part of an interview. And you certainly don't want people on your jury who are going to be considering their interview experience to be the experience of your client in the interrogation room. So this is certainly something that you should consider asking them about. Another thing that comes up is emotional trauma. And this is particularly important if you have a situation where your client is a family member of the person who is the victim of the crime about which the interrogation is happening. And you might need jurors who have an understanding of emotional trauma, or at least who are open to listening to your expert about how it can affect judgment, how somebody could be more susceptible to coercion. But there are people who think that emotional trauma and emotional stress is never going to equate to physical stress or physical trauma. So certainly, you can ask them about this. Is physical stress always worse than emotional stress? What does emotional trauma mean to you? Is that something you've ever seen someone experience? How does it affect them? And you might get a better idea about what their life experience is in regard to emotional trauma. All right, I'm going to try to finish up quick here and talk about kind of the main issue. I'm a big advocate of getting to what your case is about in voir dire and talking about false confessions, because you need to know how the jury is going to react to the fact that you are saying this is a false confession. So if their first reaction when you say in voir dire that Mr. Jones confessed the crime is, well, why the hell are we here with having a trial? I have better things to do with my time. Then you might want to ask some follow-up questions to that juror to decide if they should really be somebody on your jury. I want to speak for a second about using famous cases, because obviously you might run into trouble with your judge if you just bring up some famous case about false confessions, and that's not really the way to do a good voir dire. But you can get around this objection, and seen this happen by just asking, have you ever heard of someone falsely confessing? In the first trial of the Queen's Jogger case, the team at Legal Aid asked that question. And they were blown away by the responses that they got from the panel. It became a conversation among jurors, educating each other, really, about cases that they had heard of, documentaries they had seen, podcasts that they had listened to about false confessions. And so they didn't have to ask anything objectionable. It happened on its own by simply asking that question. So I very firmly come down on the side of asking the central question, which is, do you believe false confessions are likely to happen? And I understand that that is a product, probably, of where I practice. Because I practice in a place where the jurors, generally speaking, like to think of themselves as liberal and well-informed and well-educated, and that's not saying they are, but that's how they like to think of themselves. And so when you ask this question, you get most people saying yeah, and giving examples. But I understand if you come from a different jurisdiction where this is not the panel you're dealing with, there is some possibility that when you ask this, the three people who say yes raise their hands, and then the prosecution strikes them all, and what are you left with? So think about where you are, think about the panel that you're getting, and decide whether or not this makes sense to ask, because it may be more in your interest just to focus your time and attention on determining if they are jurors who are receptive to being educated by your expert, rather than finding out what they already believe about false confessions. And I'm going to finish with this, which, based on the experience in this room, I'm guessing I'm preaching to the choir on this, but I find that when you're teaching young lawyers about voir dire, this is the thing that they have to hear over and over and over again. And it's because it's scary, it's not comfortable when you are voir diring to talk about the worst facts in your case. But if you are giving a voir dire that is comfortable, a voir dire that is safe, you are probably going to lose. You have to talk about the bad facts, and in false confession cases, there are so many bad facts to choose from. You are going to have cases where there are physical reenactments of the crime. Your client is actually getting up and showing how they committed the crime that you're saying is a false confession. There are going to be apologies, crying, your client apologizing to the police for what they did. You have to deal with this in voir dire. You need to talk about it. You need to get the jurors' thoughts on this. There are plenty of jurors who believe that false confessions happen, but they only happen when people have major deficits. If your client is a mentally normal adult, you need to deal with it in voir dire. Could a person only falsely confess if they are mentally ill, if they're crazy, if they're a child? You have to deal with your bad facts, otherwise you have to show jurors that you're not afraid of them, you have to desensitize them, and you have to find out the jurors for whom these bad facts are deal breakers, and so that you can get them off your jury. So I hope that was helpful, and thank you.